My pleasure this morning to introduce to you a great defender of rural Missouri, rural electric cooperatives, and a true friend of our program. He's our Attorney General, Chris Koster. Chris is Missouri's 41st Attorney General, an office he's had for 2 terms. Prior to being elected Attorney General, he served in the Missouri Senate from 2004 to 2008, representing Cass, Johnson, Bates, and Vernon counties. He previously served as Cass County Prosecuting Attorney for 10 years. He's born and raised in St. Louis. He's probably going to be watching that game tonight, I'm sure. He's a graduate of the University of Missouri, the University of Missouri School of Law. He also earned an MBA from Washington University in St. Louis. The Chris Koster that I know has become the defender for rural Missouri and our issues. Whether it was the time the animal rights activists on the East Coast wanted to come in and prevent you from farming, whether it's special interest groups that come in and try to make Missouri energy more costly so we lose our competitive edge, whether it's trying to improve your rural schools or your rural public institutions, he's always been there, and he's always been there to fight. When we first met Chris, when he was in the state Senate, we quickly learned that he's a highly intelligent man with extreme negotiating skills. He has the ability to take opposing viewpoints from different organizations who may not philosophically agree with their organization's missions, and in some cases organizations that have a tendency to yell and scream at each other. But he has this uncanny ability, when those times happen, to have them leave their philosophical differences outside the room, come in, and he does his best to get them to do the right thing for Missouri. We saw that during the days of the eminent domain fight, where we almost lost our long-standing great relationship with the Missouri Farm Bureau over an issue. It got really nasty in the Missouri House. When that bill got to the Missouri Senate, the leadership of the Missouri Senate gave the bill to Chris because of his great skills in bringing sides together. He brought us and the Missouri Farm Bureau back together again. And we left our differences outside the room, and we tried our best to do the right thing. And at the end of the day, he got us to shake hands again. And I'm here to say, you all know, we have a great relationship with the Missouri Farm Bureau and Blake Hurst now, and to a large extent because of Chris Koster. Whenever issues come up that affect you, we've always been amazed that Chris Koster calls us first and wants to know what you feel about an issue and wants to know what your members feel about an issue. And he does that because he knows that you're tied closely to your co-op members, that your co-op members respect you, they trust you, and they know that their co-op is always going to do the right thing in their best interests. And I believe that's why he calls us. Whenever the proposed and final EPA rules came out, Chris was one of the first ones to call us, and he wanted to know what you think. He wanted to know what your members were thinking. And Chris, in front of all these folks, I want to thank you for making that call. And it means so much to us that you'll reach out and you ask us what these folks and their member co-ops, what they think. He's also defended rural Missouri and farmers from the overreach of EPA by the waters of the U.S. regulations. And you all know what those regulations would do to rural Missouri. He led the effort to file a lawsuit in North Dakota federal court, and they won. He won that court case. And as a result of that, because Missouri was one of the 13 states in that lawsuit, we have a stay from the rules. And I'll tell you, I travel all over rural Missouri, and they're talking about that case, and they're so thankful that our Attorney General went to bat for us and our farmers. So Chris, it's a pleasure to have you here, and thank you for what you do for rural electric co-ops.
Thank you for that. Incredible. Thank you. Oh, good. Now stop. Thank you for a beautiful introduction. Thank you. Thank you very much. Good morning, everyone, and my thanks to Barry for quite an introduction, and to all the members of the electric co-ops for the opportunity to meet and to speak with you today, and for all that you've done throughout our history for the development of rural Missouri. One of my responsibilities as Attorney General is to protect and preserve Missouri's sovereignty from federal overreach, particularly when it comes to environmental regulation. This duty comes from a sincere conviction that the people in the best position to manage Missouri's soil, air, and water resources are those who actually live on Missouri land, breathe Missouri air, and drink Missouri water, not folks who live in Washington, D.C. Guarding our state's right to regulate land usage within our borders is not just a matter of principle. It's a matter of necessity for the protection and prosperity of our economic future. My experience in the last 7 years has undermined what confidence I may once have had in the Environmental Protection Agency, and I now find myself second-guessing its judgment each time that agency issues a new rule or reinterprets its own authority. I'll give you 4 recent examples. In 2014, the Environmental Protection Agency issued a new rule on mercury emissions. The agency estimated that it would cost power plants in this country upwards of $9.6 billion per year to achieve environmental benefits worth $4 to $6 million. Think about that. EPA was going to increase consumers' annual energy costs by nearly $10 billion to achieve $6 million worth of environmental improvements. Despite this ridiculous calculation, EPA concluded that cost was irrelevant to their decision to regulate. They said it in court filings in the U.S. Supreme Court. Missouri and 22 other states sued the EPA to block that rule from taking effect. And despite the highly deferential standard of review that federal courts usually give to EPA rulemaking, the United States Supreme Court agreed with Missouri and struck down the mercury emission standards this past June as an unreasonable interpretation of the Clean Air Act. Unshaken by this defeat in the nation's highest court, the EPA, later that same day, issued yet another overreaching rule, this one redefining waters of the United States to include practically everything, from dry creek beds to farmland in a 100-year floodplain, to the ground where my own desk sits in Jefferson City. It was a power grab of unprecedented proportions, pulling in nearly 97% of Missouri's territory within EPA's jurisdiction. So, 3 separate coalitions of states sued the EPA in federal court across the country to invalidate the final WOTUS rule. And on August 27th, Missouri's coalition obtained a preliminary injunction from the United States District Court in North Dakota, halting EPA's implementation of the new rule in Missouri and a dozen other states while our legal challenges continued to flow through. Despite the federal judge's findings in that case that the WOTUS rule is most likely unlawful, the EPA chose to implement the rule in 37 other states around the country that were not part of Missouri's successful case. And an hour ago, literally an hour ago, in the 6th District Court of Appeals in Ohio, a 3-judge panel looking at the North Dakota ruling brought by Missouri, made the stay of the WOTUS rule nationwide. Thankfully, Missouri is exempt for compliance for now, but only because you and I stood up against the EPA and sued them. Now, the thing I find most frustrating about EPA's determination to micromanage our state's soil, streams, and sky is EPA's utter failure to take action when I have asked them to assist in a legitimate crisis, where EPA's expertise and responsibility are clear. In moments of actual need, EPA is nowhere to be found. In 2013, my office sued a company called Republic Services, Inc. because this giant landfill company, which operates a landfill in Bridgeton, Missouri, just west of the St. Louis airport, is running a facility that stinks of burning plastic and rotten eggs. Unfortunately, the nauseous smell that emits from this landfill may be the least of the landfill's problems. As we speak, an uncontrolled subsurface fire is burning its way through the north end of that landfill toward a radioactive waste dump on an adjoining piece of property. EPA designated the entire area a Superfund site 25 years ago, but it has never even tried to remove, to contain, or even measure the spread of radiological material stored there. For 2 years, I have urged the EPA officials to take action before the fire reaches the radioactive waste dump. Time and again, the EPA has promised solutions, but has failed to act. Now, in yet another act of Washington overreach, EPA is poised to publish its final version of the Clean Power Plan, which appears to extend its jurisdiction under the Clean Air Act even further than WOTUS stretches the Clean Water Act. In the draft rule issued for public comment, EPA proposed that Missouri achieve a 21% decrease from the 2005 level carbon emissions footprint by the year 2030. That itself was an ambitious goal. But the final rule increases EPA's proposed compliance standard an additional 76%. Over the next 15 years now, Missouri would have to reduce carbon emissions to less than 2/3 of where Missouri's emissions were a decade ago, when our state had 250,000 fewer residents. Moreover, the final rule fails to give Missouri any credit for major investments that energy producers have made in wind power since 2012. Credits that were allowed under EPA's draft rule, but which are now explicitly disallowed under EPA's final version. Assuming the EPA's final compliance standard is possible, it's clearly not affordable. Not affordable for senior citizens in small towns across Missouri, where Social Security is often the primary source of income in a community. Not affordable for Missouri's economy, whose major competitive advantage in the fight for jobs is our significantly lower energy costs relative to other states. Using figures that were provided by the EPA, Missouri's utilities estimate that complying with the Clean Power Rule by 2031 will cost Missouri consumers more than $6 billion. That's 1/4 of the state's annual budget. It's 6 times what the state currently spends on higher education every year. Missouri enjoys some of the lowest energy costs of any state in the country, just 9 cents per kilowatt hour. That's good news for our residents. It's even better news for the companies who are contemplating a move to our state. Our low energy costs are the reason why the Ford Motor Company is doing more work at their Clay Como plant than anywhere else in the United States. But the EPA's Clean Power Rule effectively eliminates Missouri's competitive advantage as a low energy cost state. In this increasingly global marketplace, it's important that state policymakers make decisions that appropriately protect Missouri's competitive footing. My skepticism about EPA's Clean Power Plan is not solely a question of practicality. It is also a question of legality. Because a significant issue exists whether the final rule goes beyond EPA's legal authority to set emission standards. The Clean Air Act may well authorize EPA to regulate sources of pollution, but it does not empower the agency to mandate the mix of traditional and renewable energy sources beyond the fence line of any given plant. Nor does it empower the agency to override Missouri's elected representatives in setting energy policy for this state. For these reasons, I have decided to file suit against the Environmental Protection Agency as soon as the final rule is published. Woo! Look, folks, I believe that climate change is real, and cleaner energy production is an important state goal, one Missouri's energy producers are already aggressively working toward. In the past 10 years, Missouri producers have added over 2,200 megawatts of generating capacity from wind power and other renewables, a number that will quickly increase in the coming years. Moreover, I know that each of us agree renewable energy is a vital piece of our state's energy portfolio, one Missouri should embrace and incentivize. Over the next 15 years, investment in renewables will bring new jobs and business to this state. However, it is essential that we achieve these goals in a responsible way that makes sense for Missouri's economy and Missouri's future. The Supreme Court has already ruled that EPA overstepped its authority with the mercury emission standards. The federal judge presiding over the Missouri challenge to the waters of the United States has ruled that we are likely to win in that case as well. And when the Clean Power Rule is finalized in the coming days, Missouri will stand up and join those states who believe that EPA has, once again, overreached the authority granted to it by the United States Congress. So long as I serve this state, I will always make the choices necessary to keep Missouri independent and economically strong. Thank you for your friendship. Thank you for what you do for this great state, and thank you for having me here today.